Welcome to Legalese. I'm Chris, and today we're going to do a deep dive into something that's way more complex than it sounds, criminal liability. And joining me, as always, is the amazing Amy. You ready to untangle this legal web?
Absolutely, Chris. Most people think it's simple, like you do something bad, you get in trouble, but in the legal world, it's rarely that black and white.
Right. We've all seen those courtroom dramas where it's all about who doing it. But today we're going deeper. We're figuring out the how and the why someone might actually be found guilty of a crime.
And you might be surprised to learn that sometimes it's not about what you did do, but what you didn't do.
Okay, hold on. Inaction can be a crime. I need an example because that doesn't seem right.
Imagine a lifeguard hired to watch over swimmers. If someone starts drowning and the lifeguard just sits there, they could face criminal charges. They had a duty to act and they failed.
Okay, that makes sense in that context. There's a contract or responsibility. Are there other situations where not doing something is actually a crime?
Absolutely. Think about taxes. We all know we're supposed to file them, right? Well, even if you're not actively trying to cheat the government, simply not filing is a crime in itself.
So ignorance of the law is no excuse.
It rarely is. We're expected to know the law and our obligations under it. And then there's the duty that comes from certain relationships, like parents to their children.
Right, like providing food and shelter.
Mm,
Those are basic necessities.
exactly. Failure to provide those, even if it's not intentional harm, is considered neglect and can lead to legal consequences.
So we've got contracts laws themselves and certain relationships creating a duty to act. But is simply having that duty enough for criminal liability? What if you weren't aware of it, for example?
Good question. For someone to be held liable for an omission, meaning failing to act, three things have to be in place. One, they have to be aware of the duty. Like if there's a law requiring you to report a certain type of accident, but you genuinely didn't know it existed, that could affect the outcome.
So it's not just about the duty itself, but also your knowledge of it. What are the other two?
You have to be capable of performing the duty. Let's say our lifeguard was suddenly having a heart attack physically. They couldn't save the swimmer, so the situation changes. And finally, you have to actually fail to act when you had both the awareness and the ability to do something.
Okay, that makes sense. But what about situations where you didn't create the danger? You just happened to witness it. Do you have a legal duty to step in?
This is where it gets really interesting. Imagine you're driving and accidentally swerve, pushing another car into a lake. You didn't mean to do it, but you did cause the situation.
Yeah, talk about a nightmare scenario.
Right. But legally, in some places, just knowing someone's in danger isn't enough to require you to act. There has to be a specific legal duty. Of course, most people would feel a moral obligation, but we're talking about criminal liability here.
So it's not always a simple you caused it, you fix it situation. There's legal nuance in there. Which brings us to another huge piece of this puzzle intent.
Yes. We call this mens rea in legal terms the guilty mind. For many crimes, it's not enough to prove you did something. They have to prove you had a certain mindset while doing it.
So it's like the difference between tripping over a wire and choosing to cut that wire knowing someone might get hurt.
Exactly. And this intent has to exist at the same time as the act. This is the concurrence principle. Like, imagine you pick up someone's phone they left on a bench absent-mindedly. No intent to steal at that moment, but later...
You decide, hey, free phone.
Right. But the intent wasn't there when you initially took it, so legally it wouldn't be theft, even if you ended up keeping it wild, right?
That's a great example.
Yeah.
So intent matters, but it's not just a yes or no thing. Are there different levels of intent?
There are. Think of it as shades of intent, which help determine how serious the crime is.
Okay, I'm definitely intrigued now. Let's break down these shades of intent. Give me the legal color palette.
The darkest shade would be specific intent. This is where you acted with a very specific goal in mind, like premeditated murder. You planned it out. You intended the outcome.
So it's not just doing something bad. It's doing it with a deliberate purpose.
Exactly. This applies to things like theft, where you intentionally set out to deprive someone of their property, or even something like attempted murder. The intent to kill was there, even if you failed.
Makes sense.
Yeah.
So with specific intent, they have to prove you had that very specific target in mind. Are there any defenses against this, though?
There are, and they can be controversial. Voluntary intoxication, for example, might be a defense if you were so drunk you literally couldn't form that specific intent.
Wait, so being drunk can get you out of a crime?
Not always. It's highly specific. Like, if you're so intoxicated you can barely walk, it's harder to argue you were capable of planning a complex robbery. And then there's mistake of fact.
Meaning?
Say you take someone's bag that looks exactly like yours. You genuinely thought it was yours, so there was no intent to steal. Even if your mistake was unreasonable, it negates the specific intent.
Okay, that one's a bit more clear-cut. So what's our next shade of intent?
We call it malice. Here, you might not have intended a specific outcome, but you acted recklessly knowing there was a high risk of harm.
So less about a deliberate plan, more about being really careless.
Exactly. Arson's a good example. You might not have meant to burn the whole building down, but you did something incredibly risky with fire and consciously ignored that risk.
Ah, I see the difference now. Specific intent. You're aiming for a target malice. You're basically playing with fire, so to speak.
Great analogy.
Mm.
Now, general intent is even broader. This is simply intending to do the act itself, even if you didn't know it was illegal or didn't want the specific outcome.
So like, I meant to punch him, but I didn't mean to break his jaw.
Exactly. With battery, you intended the punch. That's enough. And here, your level of awareness matters. Was it knowingly reckless or were you negligent? That affects the severity.
So there's overlap with malice here, but it's more about the awareness of the risk you were taking.
Yes, malice is knowing the risk and disregarding it. General intent can be less deliberate. And lastly, we have our wild card, strict liability. Here, intent doesn't matter at all.
Hold on. You can be guilty even if you didn't mean to do anything wrong? That seems unfair.
It can feel that way, but these are usually offenses where public safety is paramount. Statutory rape is a classic example. Even if you truly believed your partner was of legal age, the law is there to protect minors.
Wow, that's intense. So are there other common examples of this no excuses type of crime?
Traffic violations are a big one. Didn't mean to speed. Tough luck, you still broke the law. Same with selling alcohol to minors. The act itself is what matters.
All right, so we've got our four shades of intent: specific, malice, general, and strict. It's amazing how much complexity there is in just that one concept, but I have a feeling there's even more to this.
You'd be right, Chris. We still need to talk about how intent can actually transfer and even situations where you can be held responsible for someone else's actions.
Okay, that's for part two then. But for now, let's recap what we've learned about criminal liability so far.
It's not just about actions, but also omissions, failing to act when you have a legal duty to do so. And intent plays a huge role with different levels of culpability depending on the circumstances.
We've got statutory duties, contractual obligations, and special relationships creating those duties to act. And then our four shades of intent, each with its own examples and nuances. It's already more than I ever realized.
It's a lot to process, but stick with us for part two where we'll uncover even more legal twists and turns. Welcome back to Legalese. We're unraveling the fascinating world of criminal liability, and last time we dove deep into the concept of intent.
Right. We talked about those four shades of intent: specific, malice, general, and strict, and how they impact culpability. But you mentioned there's even more to it.
Absolutely. It gets even more nuanced when we start talking about transferred intent and vicarious liability.
Those sound like some serious legal jargon terms. Bring it down for me. What is transferred intent?
Imagine a classic Western showdown. Two gunslingers facing off at high noon. One aims at the other, pulls the trigger, but misses and hits an innocent bystander.
Oh, wow. So even though they didn't intend to harm the bystander, they're still responsible.
Exactly. The intent to harm the original target transfers to the actual victim. It's a way of ensuring that justice is served even when things don't go exactly as planned.
That makes sense. You can't just say, oops, wrong person and get away with a crime. But how does the original crime factor into this? What if they meant to kill the first person but only injured the bystander?
The intended crime is still crucial. In your example, they could still be charged with attempted murder or even murder if the bystander died, even though the victim wasn't the intended target. It's about holding people accountable for the consequences of their actions, regardless of unintended outcomes.
So it's not just about who you harmed. It's about your intent and the original crime you were trying to commit.
Mm.
Okay, that's transferred intent. What about vicarious liability?
This is where things get really interesting because we're talking about situations where you can be held responsible for someone else's actions.
Yeah.
It's like guilt by association, but with legal weight.
Wait, seriously, when would that even apply? It sounds a bit unfair.
It's more common than you might think, especially in employer-employee relationships. Let's say a delivery driver is speeding on the job and causes an accident.
Yeah, I could see that happening. So the company could be held responsible even though they weren't the ones driving,
Potentially, yes.
especially if they encouraged reckless driving or didn't provide proper training. It's about holding those in positions of power accountable for creating an environment where crimes are more likely to occur.
So it's not about blaming the company for everything an employee does. It's about taking responsibility for the systems they've created. Does this ever apply to, like, corporations as a whole, not just individual employees?
Absolutely. Think about corporate scandals where executives make decisions that harm the public or shareholders. The entire corporation could be held liable, not just the individuals involved. It prevents companies from hiding behind a few bad apples defense.
Okay, I'm starting to see how these concepts add another layer of complexity to criminal liability. It's not always as straightforward as it seems. So we've covered acts omissions, intent, transferred intent, and vicarious liability. What else is there? Remember the model penal code we touched on before? It's a framework for understanding the different mental states involved in crimes, which helps determine the severity of the punishment.
Right, you mentioned it briefly, but we kind of glossed over it.
Right.
Is it really that important?
It is. Think of it like this. It provides a standardized way to classify crimes based on the level of culpability. It helps ensure consistency and fairness across different cases and jurisdictions.
Okay, so it's more for legal professionals, but it impacts how cases are handled overall. What are those mental states again?
There are four main ones: purposefully,
Hmm.
which is the most serious, means you acted with a deliberate goal in mind, like specific intent.
Okay, so that one's pretty clear.
Yeah.
What about the others?
Knowingly means you are aware that your actions would likely lead to a certain outcome. Recklessly involves ignoring a substantial and unjustifiable risk, kind of like our arson example from before.
And lastly,
Negligently is the least culpable. It means you failed to perceive a risk that a reasonable person would have recognized.
so it's not that you intended harm, but you should have known better.
Exactly. It's still a deviation from what a reasonable person would do, but it doesn't involve the same level of conscious wrongdoing as the other mental states.
This is all really fascinating, but it's a lot to take in.
Yeah.
I think it's time for another recap. What are the key takeaways about intent and responsibility?
First, remember that intent can be transferred from the intended victim to an unintended one.
Right, like our Wild West shootout scenario.
Second, you can be held responsible for someone else's actions through vicarious liability, especially in employment situations.
And lastly, the Model Penal Code provides a framework for understanding the mental states involved in crimes, which helps determine their severity.
We covered a lot of ground in this episode, but we're not done yet. Next time, we'll explore the flip side: legal defenses. Even if you technically committed a crime, there might be circumstances that mitigate or even eliminate your culpability.
Sounds intriguing. Can't wait to dive into that. But for now, thanks for joining us on Legalese. See you next time for the final part of our deep dive into criminal liability. Welcome back to Legalese. We've been on quite a journey through the legal landscape of criminal liability, haven't we?
We have. We've explored the nuances of acts, omissions, intent, and even situations where you can be held responsible for someone else's actions.
Right. It's been fascinating, but also kind of intense. Like I'm starting to see potential criminal liability everywhere I look.
I understand. It can be a bit overwhelming to realize how many legal complexities exist in everyday life. But don't worry, there's a reason we have legal defenses.
Okay, that's a bit reassuring. So what are these legal defenses and how do they work?
Essentially, defenses are arguments that a defendant can raise to challenge the prosecution's case. They can sometimes lead to a not guilty verdict, even if the defendant technically committed the act in question.
So even if all the elements of a crime are their act, intent, causation, there might still be a way to argue that the person isn't truly guilty.
Exactly. It's not just about the letter of the law, but also about fairness and justice. Defenses recognize that there are sometimes mitigating circumstances or justifications for certain actions.
That makes sense. It's like there's the law and then there's the context of the law. So what are some of these common legal defenses? Give me the greatest hits.
Well, one of the most well-known is self-defense. This applies when someone uses force to protect themselves from an imminent threat of harm.
Okay, so if someone breaks into your house and you defend yourself, you could argue self-defense.
Potentially, yes.
Yeah.
But the key is that the threat must be immediate, and the force you use must be proportionate to the threat. You can't just shoot someone who's walking away from you and claim self-defense.
Right, that seems pretty obvious. It's not a free pass to use force whenever you want. What about defending someone else? Like, do you see a stranger being attacked, can you intervene?
That's called defense of others, and yes, it's a valid legal defense. The same principles of imminence and proportionality apply. You're essentially stepping in to protect someone who's in immediate danger, even if it means using force.
So it's like heroism is a legal defense.
Yeah.
That's kind of cool.
Yeah.
Are there defenses that aren't about using force, though?
Absolutely. One that comes up a lot is duress.
Duress. That sounds serious.
It is. It applies when someone is forced to commit a crime under threat of harm, like if someone holds a gun to your head and tells you to rob a bank.
Yeah. I could see how in that situation you might not have much choice. But wouldn't that be hard to prove in court?
It can be. The threat has to be very serious and immediate, and you have to genuinely believe it would be carried out if you didn't comply. The courts recognize that people sometimes do things they wouldn't normally do when they're facing extreme pressure.
So it's not just about feeling pressured, it's about a real and imminent danger forcing your hand. Are there any other defenses that address the mental state of the person committing the crime?
There's the insanity defense, which argues that the defendant was not mentally capable of understanding the nature of their actions or distinguishing right from wrong at the time of the crime.
That one seems super complicated. How do you even prove someone was insane at that exact moment?
It is incredibly complex. It often involves expert testimony from psychiatrists and psychologists who can evaluate the defendant's mental state. And the standards for proving insanity vary across jurisdictions.
So it's not just about saying I was crazy. There has to be a real clinical basis for it.
Yeah.
What about intoxication? We talked about that a bit before, right?
Yes, but remember, voluntary intoxication is rarely a successful defense. It might work for specific intent crimes where you have to prove a very specific mental state, but it's unlikely to fly for general intent or strict liability crimes.
So if you get drunk and punch someone, you can't really blame the alcohol.
Exactly. However, involuntary intoxication is a different story. If someone slips something into your drink without your knowledge and you commit a crime while under the influence, that might be a viable defense.
Because the key is that you weren't willingly intoxicated, right?
Mhm.
Someone else was responsible for your state of mind. This is all really fascinating stuff. I'm starting to see how the law isn't just about black and white, guilty or not guilty. There's so much gray area.
That's a great observation, Chris. Defenses are all about recognizing that there's not always a clear-cut answer to the question of criminal liability. Sometimes there are factors that mitigate or even negate guilt.
So we've learned about defenses like self-defense, defense of others, duress, insanity, and intoxication. It's amazing how these defenses can completely change the outcome of the case.
It really highlights the importance of having skilled legal representation. A good lawyer can help you navigate these complexities and build the strongest possible defense for your situation.
All right, Amy, time for our final recap. What are the biggest takeaways our listeners should remember about criminal liability and legal defenses?
First, remember that criminal liability is complex. It's not just about actions, but also omissions, intent causation, and sometimes even responsibility for the actions of others.
Right, and we learned about all sorts of interesting legal concepts like statutory duties, contractual obligations, special relationships, and the idea that sometimes you're responsible for what you don't do, not just what you do.
And of course, we can't forget about those 4 shades of intent-specific: malice, general, and strict, which help determine the severity of the crime.
And then on the flip side, even if you technically commit a crime, you might have legal defenses available, like self-defense, duress, insanity, or intoxication. It's mind-boggling how much nuance there is in the law.
It really is. Hopefully, our listeners now have a better understanding of just how much goes into determining whether someone is truly guilty of a crime. It's rarely a simple equation.
Well said, Amy. Thanks for joining us on this legal adventure. It's always a pleasure having you on Legalese.
Yeah, pleasure's all mine, Chris.
And to our listeners, thank you for tuning in to this deep dive into criminal liability. Until next time, stay curious and remember the law is all around us, so stay informed.